I'm the judge up here in the Gainesville district. Today I have the pleasure of moderating the hot topics for mediation. Today the goal of the panel is to provide an insight into the various topics required to have a successful mediation. The panel discusses the various issues, the rise of mediations, and how the parties can better plan for and participate in the mediation to obtain a successful outcome. Some of the topics we're going to be covering today are Medicare set-asides, changes from a live appearance to remote appearance in mediations, opening statements, the standpoint of the mediator and the parties. We're going to share some tips on how to have a more productive mediation. We're going to lightly touch on some COVID-19 mediations and cases. And then if we have time, we're going to get into some words and phrases that are common in English vocabulary, but might not be quite appropriate in a mediation context, which is kind of interesting. So first, I'd like to introduce our panel. We have Jason Lazarus, Esquire. Jason is the founder and chief executive officer of Synergy Settlement Services. Synergy offers healthcare lien resolutions, Medicare secondary payer compliance services, pooled trust services, settlement asset management services, and structured settlements. He is also the managing partner and founder of the Special Needs Law Firm, a Florida law firm that provides legal services related to public benefit preservation, liens and Medicare secondary payer compliance. Jason is also an Amazon best-selling author, and his book, The Art of Settlement, is a detailed guide for trial lawyers related to the regulatory compliance when resolving catastrophic claims. His written work has been cited as authoritative on Medicare compliance by the Supreme Court of Florida and also the United States Southern District of Florida. Jason received his bachelor's from the University of Central Florida and his JD with high honors from the Florida State University. He received his LLM in elder law with distinction from Stetson University College of Law. We also have John Brooks, Esquire. He graduated from the Stetson Law School in 1977, and he has been board certified in workers' compensation since 1988. John is also a Supreme Court certified mediator, and during his 39 years of practice in workers' compensation, John has practiced as a claimant's lawyer, defense lawyer, and private mediator. He has also served as a judge of compensation claims, pro hoc vice. He was a member of the statewide judicial nominating committee for 6 years and vice chairman and chairman for the board certification committee for workers' compensation. John is a member of the William Whelan Inns of Court in Orlando, and he is a certified Florida bar instructor for workers' compensation. He currently serves as a state mediator in the Office of Judges Compensation Claims in Daytona Beach District. And next we have Jessica Carrier, Esquire. Jessica attended the Indiana University in Bloomington, Indiana, earning a Bachelor of Arts in 1998. She attended Nova Southeastern University, Shepherd Broad Law Center in Fort Lauderdale, Florida, earning a Juris Doctorate in May of 2002. And since 2002, Jessica has represented both the injured worker and served as defense counsel, representing the interests of the employer, carrier, and servicing agent. She has also served as an adjunct professor in civil pretrial practice at Nova Southeastern University, Shepherd Broad Law Center from 2009 to 2010. Jessica is fluent in Spanish and is certified by the Madrid Chamber of Commerce and Business Spanish. Since May of 2018, Jessica served the state of Florida, specifically Manatee and Sarasota counties, as a senior attorney and as a state mediator for the Office of Judges of Compensation Claims. I'd like to thank our panel for being here today. Now, in mediations, frequently Medicare set-aside issues come up because a Medicare set-aside is required. And with that, there's issues that come up and certain things you have to look at. And Jason's going to take us through some of those things. So Jason, you want to start us off?
Thank you, Judge. So, the focus of my talk today is really about issues that you should be addressing when you're mediating the claim to make sure ultimately the Medicare set-aside portion doesn't become a problem or an impediment to getting the case finally resolved, because these issues, when they're not dealt with, typically cause problems after the mediation. And that's a part of what I see in my practice, is dealing with lawyers who are trying to get to the finish line. And some of these issues, when they're neglected at mediation, cause a lot of problems at the back end. So I'm going to go through just some different topics that are important to have agreement on by the parties when the case is being resolved. The first one is funding methodology of a Medicare set-aside. Medicare has two different options. One is a lump sum and the other is annuity funding. Electing a funding methodology is important because when you submit to CMS, you have to submit with the proper funding. You can't submit annuity funding, but then do lump sum funding and vice versa. And it's important just to know quickly the differences between the two and why one might be preferable to the other. With a lump sum, that means that there has to be complete exhaustion before the MSA can be utilized versus annuity funding, which has 2 years worth of seed, which is the first surgical procedure, and 2 years of annual payments plus future annual payments coming in via a structured settlement annuity. That type of funding allows yearly exhaustion of the Medicare set-aside. So a big difference in terms of what happens with an MSA, but the critical part is the parties determining what type of funding will be utilized, because when it gets submitted to CMS, it needs to be done with that. And generally, the annuity funding of MSAs is preferable because it's typically going to be a lower cost because of the rated age. That's going to reduce the total amount of the MSA and the cost as well, because pricing is based on life expectancy, and CMS uses the rated ages as proof of reduction of life expectancy. And because of the taxability of the structured settlements, because they're not taxable, it's usually a preferred funding methodology for the Medicare set-aside. And just briefly, if you're going down the path of an MSA that's annuity funded, there's 3 different types of funding methodologies that are used. And it's important to know this because it is also important to agree upon that as part of the settlement. There's temporary life, there's life with a premium guarantee, and then there's a period certain matching CMS life expectancy. So the temp life is the cheapest way to fund for the carrier, but for the claimant, it means if they die, the annuity ceases and there's no money that's paid out to their beneficiaries at death. The life with a premium guarantee adds that guarantee on. So if the claimant passes away prematurely, then money goes to their family. This sort of is kind of the middle ground because it is a solution that allows for protection of the carrier and the claimant, and it's usually pretty cost effective. And then the last one is the period certain, where it's set up for the specific number of years for remaining life expectancy that's used by CMS for calculation of the MSA. That's typically going to be the most expensive methodology, but it also doesn't overfund the MSA. When you do a lifetime payment, technically it overfunds the MSA if it goes beyond the life expectancy CMS uses. So those are the primary issues when it comes to funding methodologies. Next up is non-Medicare covered expenses. This is something that typically is overlooked by the parties. The MSA is only going to protect for future injury-related care covered by Medicare, so it will not pay for anything other than that. If there are significant non-Medicare expenses that are being paid by the carrier, the question is what happens at washout? This can be a pretty large component of damages in certain cases. Obviously, from the claimant's perspective, it increases the value of the case and the carrier's exposure, but both sides really need to understand the cost to fund that non-Medicare covered expense portion. And there's a lot of non-Medicare expenses that can be fairly significant. For example, attendant and custodial care, dental care, medications that are not covered under Part D, eye exams, dentures, cosmetic surgery, hearing aids, transportation, home modifications. Those are some of the main ones that are non-Medicare covered expenses that can arise. And there are companies like my company does this, that does a report that does the MSA, does the non-Medicare covered expenses, and any Part D that might be out of pocket. So there's an actual report that's generated that details over all of those expenses so that the parties really know what the true cost would be to provide for all of those particular services. Whether or not the settlement will encompass all of that's another story, but it is something that's frequently missed and overlooked, and the parties really need to make sure that that issue is addressed somehow, some way. So next up is submission of the MSA. One of the things that typically is not agreed upon is whether it's going to be CMS submitted or not, or where problems arise is where the parties don't agree to this at settlement. So remember, for purposes of CMS submission, there are these review thresholds. So if you've got a Medicare beneficiary and the total settlement is greater than $25,000, that is one that CMS can review. If there's a reasonable expectation within 30 months of Medicare eligibility and the settlement is greater than $250,000, that is something CMS will review. The parties never want to require CMS submission if you don't meet those review thresholds, because you're setting up a contingency that will fail. So you've got to make sure that you are aware of those thresholds and the parties come to an agreement as to whether this is one that CMS will review and fits within those review thresholds. And if you're going to submit to CMS, you really need to make sure that there's agreement about who is submitting what, and if possible, even if the parties discuss pre-mediation about submitting that to CMS, even better. But again, make sure too, if submission is going to occur, that the proper funding method is submitted as part of that. And these are all things that the parties can agree to as part of the mediation to make sure that there are no issues on the back end. So next up is review of the MSA. So if it's going to be submitted, the parties need to discuss and agree what happens if CMS comes back with an increase in the MSA. Obviously, they can decrease it. That's rare. Usually we do not see a decrease. Usually it comes back at a higher number. So then the question becomes, who has the burden if the number comes back higher than what was submitted? But some things to keep in mind too is that there are things that will delay CMS review. So if possible, the parties can agree at mediation about who's doing what and making sure that prerequisites are handled. For example, making sure that consent is signed by the claimant, making sure that everything that's necessary to be submitted to CMS is going to be provided and who's going to provide it, making sure that the medical records and payouts are current. Those are all things that can delay a CMS review response. And there was a change as of April of 2020 that the claimant now must be presented with the complete CMS submission packet and approve of it before it's submitted to CMS for review. The parties should be addressing that requirement as part of the mediation. And also, at the end of the day, making sure that you've got a up-to-date allocation report, because if the allocation report is older than 6 months, it needs to be updated before it's submitted to CMS. And one of the things too is, remember, review and submission is voluntary. Most of the time the carriers do require it, but the parties could agree that it's not going to be submitted. That is a preliminary, obviously, question that needs to be addressed at mediation. There are some really common errors that CMS has identified in terms of submissions of MSAs. And these are things that, again, if the parties talk about this at mediation, they can avoid the potential of having an MSA that's not reviewed timely. So top submission errors are incomplete or insufficient medical records for the last 2 years of treatment, exclusion of certain medical records or submitting too many records, insufficient proof of medications, carrier payment histories being missing, undated or old or incomplete, a total settlement amount not being submitted or it's not properly computed, no response or insufficient responses to development requests. So as CMS is reviewing it, who has that responsibility? Talking about these things at mediation, again, is important. A proposed settlement, proposed set-aside allocation not clearly divided between medical and prescription drugs, submission of unnecessary, unrelated, or duplicated documents, incorrect references for a state that does not have fee schedule, no rated age statement submitted, incorrect pricing of drugs, or multiple dates of injury, multiple body parts, or body parts remaining open for medical. So those are all things that can cause a delay in CMS review. So keep those things in mind when you're mediating the case, because if you can get agreement on as much of this as possible, then you avoid having problems down the road. It's also important for the parties to remember and talk about that there is no formal appeals process adds to the amount of the MSA. There's re-review and amended review, which are two options if there is some dispute as to the amount. The re-review is only open to mathematical errors or missing documentation that CMS did not get when the MSA was submitted. The amended review is a one-time request for re-review if CMS had issued approval of the MSA at least 12 but no more than 72 months prior, the case had not yet settled, and the projected care has changed such that the new amount would result in a 10% change or $10,000 change in CMS's previously approved amount. So again, talking about what happens with CMS review and the potential avenues is important to have agreement for the parties. Next up is controverted claims. You can't ignore or those denied or disputed conditions in light of Section 111, because these things are getting reported to Medicare. So you've got to make sure the parties know how they're going to address any of those types of situations when the MSA is being submitted. So if the MSA fails to include disputed conditions, and those disputed conditions are released and then reported to CMS under Section 111, CMS can view themselves as a secondary payer as it pertains to those, which can cause a real problem. So again, an important thing to keep in mind, and in those instances where CMS does take that position, basically they can determine that the entire settlement has to be exhausted prior to paying for anything. So it can be a significant issue. Also, when the case is resolved, addressing what's going to happen with administration of the MSA. If you've got a claimant who cannot self-administer because they're incompetent or have a representative payee, then you want to address professional administration. The parties also need to address what happens at death, making sure that either there's inclusion of a reversionary clause if that's desired by the carrier. Those sorts of things are important. And also agreement as to what type of professional administration solution might be utilized, whether it's a custodial agreement or a trust solution. And there are instances where a client is dual eligible, so Medicaid and Medicare, in which case you're going to need a trust to keep that claimant eligible for Medicaid if they've got that dual eligibility. And that's it. I hit the major things pretty quickly, so I'm probably running a little bit less on time, but I think that will keep us on track. So I will turn it back over to Judge Stanton.
Okay, thank you, Jason. That's some good information. And mediation with MSAs, it's always a concern. You always have address a lot of different issues, and you really hit some good highlights on that and stuff for people to really look at in the future as far as remediations when they get into it. So thank you for all that information. Next, we've had some changes in mediation appearances in the last few months, as we all know. We've had changes from a live appearance to a remote appearance. And I'm gonna let John, you want to discuss some of the things that happened with that? John, can you hear me?
Judge, I'm having a little bit of internet problem. I'm just going to go ahead and start. I'm assuming that, are you hearing me on my end, on this end?
Yes, I'm hearing you.
Okay, because you're there and then you're not, but I'm just going to go ahead and go. Obviously, in the last year or so, we've had a very drastic change in the way we do mediations. And technology, as we discover, can be both good and bad, reliable and unreliable. But we have seen some changes that have occurred, and I suspect that once this pandemic is done, a lot of these changes will probably remain. So it would bear in mind to get used to some of these things. In my practice in Daytona Beach, we have two methods of doing mediations. I don't do Zoom. I've done a few, and I'm not going to talk about Zoom mediations. They have their own problems and advantages and disadvantages, but I've only done a few of them, and I don't have a lot of requests to do them. So I'm not going to address that at this time. I know some private mediators do a lot of it, but I'm going to talk a little bit about what we do here and give you some pointers on that. Before I get started though on that, I wanted to bring up some rules on mediation in general that a lot of people sometimes don't remember. Under Rule 6.1105, the rule requires there be certain people at a mediation. And sometimes we forget that this rule is out there, but the rule says these people shall be there. And that's the claimant, the adjuster, and the employer if he's not represented by an insurance company, and the attorneys. And they are required to be there. And sometimes we end up at a mediation and there's somebody missing, but I point that out to you that that part of the advantages of the new technology we deal with is it makes it a whole lot easier for these people to be there. So, but they are required to. And the appearance of an attorney does not excuse or dispense with the requirement of the appearance of a party. A couple of other things, and that has bedeviled everybody who deals with this through the medium of telephones and conferences and Zooms, is that the mediation, and this is also Rule 6.1105, and I think it's B or A or B, it says that the mediation does not end until the settlement documents or the resolution documents or whatever they happen may be are signed and returned. And so I can't tell you how many mediations technically continued on for a little bit longer than the date of the mediation. Probably half of them get back the same day, but most of them do not, or a little bit more than half of them do not. And I probably spend a good hour of my day tracking down mediation reports, settlement agreements, resolution agreements to try to get them into file. But the rule requires that they be submitted the same business day as they go out. A lot of them are, but many of them are not. And I just remind you that that is the rule. And then until you send them back, technically the mediation has not ended. Now, I do two mediations and have done two kinds of mediations. One is the conference call. And this is where I was doing this before COVID, is I would notify the defense attorney to get the claimant's attorney on the phone at the time of the mediation. The claimant's attorney could get the claimant on the phone. And then we basically had a conference call scenario. And that worked fine. It does limit the number of people that you can have on the phone. It also is limited by the skill of the attorney who's doing it. Some of them have very little skill at doing this, and it's always dangerous to see who they connect with. But it is something that we did a lot of. It does have its limitations, but it's usually a good method to do it if you're going to do that way. Part of the problem with that is if you are in a conference call that's initiated by somebody else, if you want to talk to the other party by themselves, you've got to hang up and call them back. And so there are some limitations to doing it. I don't do them anymore, or I do very few of them anymore. And that's what I want to talk about next is the conference call. Probably 95% of all the mediations I do are used through the open voice provided by the state, and I send that conference call number out with the room number, and we do them that way. And there are a lot of advantages to doing that, and I've liked it very much, and I've gotten used to doing it through there. And I suspect once this COVID is over, I suspect we'll still be doing a lot of them that way. The biggest advantage is that really, other than a superficial limit of like 35 or 40, you can have as many people in that conference room as you want. And so what I've seen is, excuse me, what I've seen is that we've had a lot more adjusters. appearing for mediations than we ever used to have before. Because when we did conference calls, the defense attorney would have to conference in the adjuster, and sometimes that was easy to do and sometimes it wasn't. This is a scenario where the adjuster has the phone number for the conference room and then jump right in. So we've had a lot more adjusters appearing than I've ever had appearing. But part of the problems that we do when we get a bunch of people into a conference room is that, just like in a room, in any other room, you get people talking over each other. This is one of the disadvantages to doing a conference room, is that sometimes you get two people talking at once, and because of the way the phone's set up, when one person's talking and another person starts talking, it literally cuts off the conversation of the other person. So that, unlike being in a room, you're really not hearing two people, you're hearing one and part of another and part of another and part of another. The other problems, a couple of other problems doing this with the conference room is the use of speakerphones. And this is simply technology. Some people have really good speakerphones, some people do not. And sometimes you get a lot of reverb, a lot of echo, or you just simply have a scratching in and out, or you get noises that you have no idea what they are. And I found that in 90% of the times that we get them, the problems is because of the use of the speakerphone. The other problem with the speakerphone is a lot of them are cell phones, where the speakerphone is not as good as a land-based phone. But we've also had the interesting phenomenon of background noises. A lot of attorneys and adjusters and et cetera work from home. And sometimes you'll get the sundry barking dogs, screaming kids, and nagging spouses enter into the conference room. And while this can be, add some flavor to the mediation, it's something that can be distracting, but it's something that we've never obviously had before. So it is one of those drawbacks if you're doing a conference room, is you have everything comes into the room. The other thing that I've noticed, and I wanted to mention, is, whether or not you should make a demand or an offer while everybody's there in the conference room. And normally what I do is, whether there's been a demand made or an offer made, I usually ask the attorneys, do you want to go ahead and make an offer or a demand while you're in the room, or do you want to talk to me separately? And this is where the advantage to this conference room comes into play, is that 90% of the time they say, I would like to talk to you first before I make a counter offer or a demand or whatever. And that way it allows me to leave them in the conference room and excuse the other parties out. In other words, tell the defense attorney and the adjuster, whoever else is there, to please leave. And I don't have to call back the claimant's attorney and the claimant who are already on the phone to talk with them about a demand. I'm going to mention a problem with this. And this occurred to me early on when using this conference room. Is we did this, and I had the claimant's attorney leave, and the part of the problem was he had his client on his own phone in another room or something, and I'm not sure what happened, but at some point in time in the process of the conference, the claimant called into the room. Now, if you've been in the conference room, you hear a little beep, which tells you someone's entered the room or someone's left the room. Well, when you got a lot of people talking, or they're talking and you're listening to them, sometimes you don't hear the beep. And apparently this claimant called into the room and was there. So when I told the claimant's attorney, because he was the only one I believed to be on the phone, I said, please leave and I'll talk to the defense attorney and the adjuster, and we'll get you a demand. And we did so, and we proceeded to have a conversation, not very long. And there was some interesting discussion, but it was a proper discussion, but it was a legal discussion type of thing, and the strengths and weaknesses of the case. And after we hung up, and I didn't know the claimant was there at all, the claimant apparently called his attorney and said he listened in on the conversation and was very disappointed to hear him, his case referenced not very good case and problems with the case, and you never told me about any of this stuff. And the next thing you know, basically the claimant was firing his attorney. And so this erupted. Claimant's attorney called me back, told me what happened, and I said, I really apologize. I had no idea. So a couple things to know. In the conference room scenario, under the open voice, there is a mechanism where you can click a button and it tells you how many people in the room. It doesn't tell you who they are, but it tells you how many people are there. But I've gotten into the habit when I do this, when I've asked the people to leave, I will stop and I'll say, is there anybody else in the room? Or, just to make sure, is only so-and-so and so-and-so in the room? Is there anyone else in this room? And I think when you do that, then you cover yourself, but I certainly suggest you doing so before you begin having a conversation that you think is going to be private, because sometimes there may be somebody else in the room. It is possible, and I want to make you aware of this in the open calls that the state uses, is if somebody else has the number and room number, which is a very common number, they can call in to that room while you're there, but there'll be a beep so that you know somebody else has entered. And usually when I hear somebody else entered, I ask who's there. If that, and I've had it happen once where the person, whoever it was, didn't answer. And at that point, I had everybody say, this conversation's over, I will call you back separately. And I did so, but that is one of the drawbacks to that. The other drawback to doing this all by phone is sharing of evidence. Normally, when we had everybody here live, if somebody had some documents that they wanted to show the other side, they would walk them over from one room to the next, or they would give them to me and I would take them over and show them. This was particularly true with regards to surveillance videos or surveillance pictures or recently received medical reports or the typical, I sent this to the doctor after my phone conference with him and he signed this thing and this is what he said. And doing it by phone, the best you've got is to scan it and send it. And this usually takes time and this usually causes delay in things. And it's just not, it's a slower process than we had before, but it's one of the things that we have to put up with when we do telephone mediations. And the other thing, the final thing is the signing of paperwork. And this has been the biggest drawback to doing mediations by phone, is getting the documents signed. And like I said, I spend a lot of time tracking down people to get them signed, to get them sent in. And if there are changes made, they got to be made and sent back and rescanned and sent back. So, it's and the other thing is, which is, and I think I mentioned this, that the mediation isn't over until it's signed. And a lot of people don't know this, and I don't bark at anybody about this because I usually designate the mediation as settled, assuming it was. But that is a rule. And so, I tell people, make an effort to get the paperwork in, to get it in that day or the next. Because the longer it waits out there, the more something can happen without any paperwork being signed by both sides. So there are some drawbacks to doing by phone, although I think the conference room mediation to me is the best way to do it at present. And I suspect that when this is all over and we are in telephone mediations up until the end of February, according to Judge Langham, I suspect it'll go beyond that as well. So I think we're going to see this a while, and even after we don't have to, I suspect we're going to get requests to do it on a fairly regular basis, and I think we probably will, because I don't have any problem with doing it by phone, and I probably will grant them fairly freely. And that's it on that.
Okay, great. Thanks, John. Now, in mediations also, opening statements frequently come up. Sometimes you want to do them, sometimes you don't want to do them. It becomes a issue that's got to be resolved also as far as that. And so Jessica is going to take us through some of that as far as the opening statements and when to do it, when not to do it, and effectiveness and such as that. Jessica?
Thank you, Justin. I'll start with citing the 60Q rule 6.11 subsection 2. Which outlines the duties of a mediator. Of course, we know that the mediator shall inform the parties at the beginning of the mediation about the mediation process, the role of the mediator being an impartial one, serving as a facilitator between the parties to assist towards either resolution of the pending claims or towards a voluntary settlement. The mediator is to explain the difference between a mediation and proceeding to a final hearing, explain that the process is consensual in nature and that the parties retain their right to a final hearing if they do not reach an agreement at the time of mediation. Most importantly, to explain that the communications that are heard and made between the parties are all confidential and privileged in nature. And of course, again, explain that if an agreement is reached at the end, the mediator will prepare a mediation agreement that is all by consent by both parties, and it will be reduced into writing and require approval by the judge if necessary. The mediator is to be in control of the mediation and the procedures that are followed in the mediation. Whether the mediation is in person or by telephone, My practice is to initially speak with each side privately, to introduce myself to the parties, engage the injured worker and the employer and the carrier representative, assess the room if it's in person, or feel out the parties by telephone to determine whether or not a joint session would be beneficial to the mediation process. After that, if a joint session is required, we either use a conference call number or I join the conference, each telephone line separately. I find that speaking with each side briefly and obtaining consent from both sides for participation in a joint session ensures the consensual nature of the mediation process and avoids unnecessary heated presentations during the joint session. There are occasions due to the nature of the injuries where a joint session may not be fruitful towards resolution of the claims or toward settlement. Some examples, if a claim involves a death case and you have a widow and children present, if a claim involves catastrophic injuries where you have family members that are providing attendant care, a claim that involves psychiatric injuries or any other otherwise highly emotionally involved claim, may not be appropriate to have a joint session in those kinds of situations. Another type of claim that I may consider that a joint session isn't appropriate would be a claim that is denied and you have the employer representative present and the employee, and there's a very contentious relationship between the two and can get heated. So in those situations, I usually separate the parties if they're in person, or currently I just go ahead and speak with each side privately and serve as a conduit between the two parties. Another would be when a claimant is unrepresented or you have an uninsured employer. Usually in those situations, I go ahead and split everyone up at the beginning and then just serve as a conduit between the two. Ultimately, I feel that leaving the decision to participate in a joint session to the parties allows them to be engaged and a little bit more comfortable in the mediation process itself. If the parties choose not to participate in a joint session, I will explain the mediation process pursuant to the rules, and then I'll proceed from there. I have had occasions where a party is unwilling to participate in the mediation process altogether unless they have the opportunity to present their case in a joint session with the other side present. And that presents a series of questions I think are interesting. Does a party have a right to an opening presentation or joint session? Does the mediator have the authority to require that all parties and their counsel be present for the purposes of obtaining a presentation from the claimant or the employer? And with respect to that, I can look to a mediator qualification advisory panel opinion identified as 95-009A, where the panel confirms that mediation is a consensual process, not based on the power or authority of the mediator. When the mediation is court ordered, like Mr. Brooks and I handle, the parties are required to appear. The panel believed that in a court ordered situation, appearance at mediation includes being present for the mediator's introductory remarks pursuant to the Florida Rules of Certified and Court Appointed Mediators. It does not discuss anything else, which leads me to my third question. Does refusal of a party to give a presentation or listen to the other side's presentation constitute a failure to appear at mediation? The MEAC panel advisory opinion that I looked into identified as 95-009B. In that opinion, the panel advised that if the parties are willing to participate in the mediation process, but are unwilling to give a presentation or listen to a presentation in a joint session, that does not constitute a failure to appear. Therefore, the mediator may not report such a failure to the court. I think these advisory opinions are important because they believe they preserve the right of self-determination, which is integral to the mediation process and ultimately to a successful and fruitful mediation. Judge Stanton and Mediator Brooks, I don't know if either of you dealt with those types of issues. If you have, how have you handled them?
Well, normally in opening statements, you know, I'm very much to leaving that in the hands of the attorneys, whether they want to make one or not. And my theory is it is their mediation, and sometimes there's an advantage to doing one, you know, with an in-your-face mediation or, you know, otherwise. But I very much leave it at, I don't require them. I never require an opening statement. I leave that to the parties entirely. And I found that to be, they know what they're doing. They know what they want to say, and every case is different. So, you know, my theory is it's their case, and I'm going to let them do it the way they want to. And I don't require them to do anything with regards to an opening statement. I may have them do an opening statement to me separately, because at some point I'm going to ask a lot of questions, but that may be totally different than any opening statement they would want to give.
You know, also, at one point when I was a mediator, I did the same thing. I let the parties kind of agree upon whether openings or not, but I always found openings to be pretty beneficial if the parties want to do them, because each side gets to hear the other side's arguments or positions. As long as what I always kind of say, it didn't end up being a scorched earth type presentation. And those presentations generally didn't go very well as far as openings. So, but I usually found them pretty effective if they wanted to do them. But thank you, that's some good information. Next, we're going to move into what are some tips for a productive mediation. Some things that parties probably already do, but if not, it's a good reminder as far as what we can do to have a better mediation outcome for it. John, you want us to talk maybe about a few of those?
Yep, I'm gonna, in fact, what I thought I'd do is, let me take B through F, and Jessica, if you could take, or B through E, if you could take F through I, you know, let me go that way. So the first one is, and a lot of these, as the judge indicated, these are things you know, and certainly should know, and none of these are other than duh type of things. But you know, it's amazing when you get into a mediation how many of these are not done. The first one is a pre-mediation conference. And normally you would say, well, of course. But pre-mediation conference is unbelievably essential. For the claimant, it is explaining to a claimant what he can expect as far as the range of offers. In other words, what's the value of the case, and give him a good range and tell him why. I spend a lot of times in mediations trying to explain to a claimant why he's not entitled to pain and suffering, loss of enjoyment of life, and etc. Some attorneys just don't, it's not that they don't know, it's just that sometimes they don't tell their clients that. And so give them a good range and give them the reason why the range is in that, so that when they come, they're not, you know, affronted and you know, start pulling up stakes. And with adjusters, kind of the same thing. You want to give the adjuster a realistic expectation of winning the case if there are issues in dispute that you may be going to a hearing on. And you also want to maybe give them a little bit of information about the claimant's attorney, what they can expect from this particular attorney, because some attorneys are a little bit different than others, and adjusters need to know what they're going to be dealing with. And it's always good to give them an advance, as opposed to them getting pissed off in the middle of the mediation over the claimant's attorney saying A, B, and C, when they feel that that's totally improper, but that's what the claimant's attorney in this case does. The other thing is, you know, I tell defense attorneys is get your client before you get there and come up with 3 numbers: a will do number, a maybe do number, and a hell no will never do number. So that during the process of the mediation, I, as a mediator, began to sense where you're definitely not going, where you definitely will go, and then the middle ground there to see if the claimant will be in that same range. So, but you have needed to have figure out what those numbers are before you got there. The other thing is, and I say this because you would say, you know, you should have a pre-mediation conference. This is not something, you know, we need to be told. I get here and there are a lot of occasions when there has not been any pre-mediation conference, either with the claimant or the adjuster. And it could be for many, many reasons. And so I tell you, if you cannot get a hold of your claimant or you can't get a hold of your adjuster before the mediation, call and move the mediation. Don't go to a mediation without a pre-mediation conference. It's just doomed to death if you do. So I'm more than happy to grant a move and continuance of the mediation if that's where you're going. The second, file review. Again, this is something you say, but it's amazing that I've had attorneys on both sides, claimants, attorneys, and defense attorneys in the mediation who clearly have not reviewed their file. And the file can contain anything, including, the actual petition for benefits. What are you asking for? Because sometimes they get here and they have forgotten what they're asking for. And there's usually a response, and then you ask the defense attorney, well, what's your defense to their claim? Well, I'm not really sure, or it's this or that. And I said, well, you have a response here that says it's this, and they haven't reviewed it or they haven't seen it. And so a review of the file just to give you an idea of what you're doing there and why you are there. And it may be that you get there and all the issues have been resolved. That's fine. Then you use it for the purposes of trying to settle if that's what you want to do. But if you don't want to settle a case and all issues are resolved, this is something you needed to have known before the mediation conference, because doing useless mediations is something that I don't really have the time to do. Medical records and opinions. These are also very, very important. But what's interesting about them is that workers' compensation works on medical records, medical opinions, all of that kind of stuff. Nothing happens in workers' compensation without them. And sometimes or often we get into a mediation where one side or the other references a medical report or a medical opinion or a medical visit that the other side does not have. And then you're involved with sending the medical report, sending the medical records over, letting them review it, then they talk to their client and see where it goes. And now you killed 30 minutes out of a mediation doing that. Make sure all of the records are there on the other side. Whatever you've got, send them to the other side, respond to the request to produce, have all of that done before you get to the mediation. Because when you're talking about things like MMI dates, permanent impairment ratings, restrictions, all kind of stuff where it comes into play, both sides need to know what they are and you need to know what they are. And so review the medical records, make sure the other side had, because if you got a killer medical report, let the other side know before the mediation, because it's, it just simply causes a stoppage in the mediation process. And now you're having to remediate the case based on new information. So make an effort to get all the medical reports and records to the other side. And if they are critical and you don't have them and you need them, ask for continuance. In other words, move the mediation date. Get the records before you get here. I do a lot of recess and reconvening, waiting for medical records to come in. And that's okay, but if you know beforehand you don't got them, just call me and say, we need to move it. And that way, nobody's wasting their time. Financial numbers and authority. Now, these come into kind of two different categories. One of them is permanent total evaluations. Some people use companies to determine permanent total, excuse me, although it's not as difficult as it used to be when permanent total could run forever. But it's still and we're not arguing over 8%. We haven't seen 8% in 20 years, but you're arguing sometimes between 1% and 3%. But if you have a permanent total number or a present value number, bring it in and explain why you got it. In other words, explain the number you're using. Because sometimes the other sides may be totally different, and I'm going to say, why is there such a difference, and be ready to explain your numbers, and it just makes things go faster. The other thing is the biggest problem that we deal with in dealing with numbers, I have to say, is temporary partial benefits. We get to a mediation and there's a claim outstanding for TPD from the date of accident until ongoing, and the other side, the response is, we paid all temporary partial benefits that arose. Period. Well, I tell the claims attorney, look, the burden's on you. Tell me why, why money's owed. Well, he worked some. Okay. Do you have the numbers? And they say yes, or they send the numbers and they have the payroll records, and now you're sitting there at a mediation. And I have spent mediations 2 hours just doing nothing but taking week by week, going down all of the records to determine how much was owed for this week and how much was owed for that week. And this is especially true if you've got a 2-week period and a 2-week pay periods. And, as I keep telling these people, temporary partial is not a 2-week scenario. It's a week by week. And so you have to break the 2 weeks down into numbers that can now make sense so you can plug the numbers in. All of this should be done before you get to a mediation, and should be passed on. If you're the claimant's attorney, the burden is yours. Send the other side a breakdown of the weeks, how much was made, what's the average weekly wage. If you got an issue over the average weekly wage, show it with what your average weekly wage you say it is, and put some numbers out there. So that, are we looking at $10,000 owed, or are we looking at $300 owed? Because all of this makes a great deal of difference. And if we spend a lot of time doing it in the mediation, then we're just simply going to run out of time in the mediation, and then you've not solved anything. And the other side needs to do the same, because if they got a number and you don't have a number back, well, you know, what can you expect other than their number's right? I think that's I want to make sure I got all that in there for that. Again, with regards to numbers, I tell people that one of the reasons why I went to law school is that I don't do numbers. And so you need to have whatever you're dealing with, whether or not it's the P&I, the penalties and interest, or it's a gap period of temporary benefits missed. Come with your numbers, show why it's if you say it's $3,000, show me why it's $3,000. Be able to show the other side why it's $3,000, and so that they can look at it and say, yes, we agree, or no, and here's why it's not. Because otherwise than that, you're basically just guessing. The other side then is guessing, and you might be able to reach a resolution of the guess, but if you got the numbers and you got them locked down, you're in a much better position than if the other side doesn't have them. Because if they can't argue with your numbers, then they really got to buy your numbers. So if you're going to get the numbers, get them right, and bring the numbers to the table, but bring the numbers to the table before you get there, so that we're not trying to figure it out at the mediation, but they know what it is when you get there. Jessica, pre-mediation demands.
I would say that an effort to forward the payout ledger reflecting everything that's been paid medically and indemnity-wise to the claimant's attorney prior to mediation will allow that attorney to discuss it with his client and also assist the claimant's counsel in preparing a mediation demand beforehand. A lot of times you'll have situations where, because the attorneys have not exchanged that information, the demand will be discussed and it'll be an hour or two, and time goes on, and then they'll present a demand at the time of mediation for the first time to the employer carrier. That causes a couple of issues. If you're receiving the demand as the employer carrier at the time of mediation, it may not be in a position to respond. So you may have to recess and reconvene to allow the parties to obtain settlement authority based on the demand they just received. So I think it's important to exchange those types of documents beforehand. Make sure that, like Mr. Brooks said, go ahead and exchange all of the medical records ahead of time so that you and your client can prepare an appropriate demand and forward that ahead of time so that the mediation itself can be more fruitful.
And then we got negotiations.
With negotiating, obviously, if you begin with a demand of $1 million, you're going to shut down negotiations pretty quickly. So it's important that you look at the file and assess the exposure and talk to your client about a reasonable demand, understanding that, of course, you're going to be moving off of that demand. So give yourself room to move, but providing a initial demand as a claimant that is 4, 5, 6, 7 times the amount of the potential exposure of the claim usually shuts down the communication very quickly, and you'll end up with a counter offer that is very nominal, such as $100, and then the negotiation itself is just not fruitful that way. So I encourage the attorneys to present a reasonable demand. Of course, with the authority of your client, that's another issue that I think is important. You have attorneys that may believe they have discussed something with their client, get your authority from your client in writing that they will accept X before you go ahead and commit to anything, because that causes issues as well. You know, the parties can continue negotiating, then all of a sudden there is no settlement because the numbers weren't communicated appropriately. And I find that if an employer carrier really wants to settle a case, they will present an offer regardless of whether or not they receive a demand from the claimant. And that sometimes can allow the parties to go ahead and discuss the benefits of settlement versus proceeding to final hearing. So those are all things to take into consideration for both sides.
Now, I know we touched on this a little bit. As far as mediation reports, do you have issues getting them back also?
I do. I like Mediator Brooks spend probably a good hour every day sending follow-up emails to attorneys saying, hey, where's my mediation agreements? But for the most part, they've tried to be good about it. But it is a process because of the fact that a lot of times if the attorney, for example, wants the claimant to sign the document because they're not comfortable with authorization from the claimant to sign a document for them, then that'll take a bit longer. A lot of injured workers don't have access to computers, printers, all those kinds of things. So that if you have a scenario like that, it will take a little bit longer than that's expected, and it's not a problem. When the clients provide the authorization to their attorney to sign on their behalf, it tends to work a little bit better. And I confirm that that's the case with the clients on the phone before I proceed with sending over the mediation agreement to the parties.
One of the things that you might want to note is, and a lot of attorneys don't know this, is under the rule, and it's in one of the Q rules under 6.110, is that the rule specifically provides that a signature of the attorney binds the parties. In other words, that just the signature of the attorney alone is sufficient. But as you know, it is always a lot of good idea to either get the claimant to sign it, in this case, or you have the claimant on the phone and say, is it okay if your attorney signs for it, and get permission for him to sign it, and even though that their signature is enough.
Okay, great. Now, I don't know how many of these we have coming through now, but as far as COVID-19 cases, have either one of you had any of those come through yet? And as far as, we're going to talk a little bit about that without getting maybe specifics, but obviously, but.
Yeah, I've had 3 of them come in, and we just got a little bit of time left. Let me briefly mention on that. You know, obviously you're dealing with 440.02 under the definition of exposure cases, and it presents an extremely, probably near impossible burden to prove one. You know, and I've had some that looked really good if they were any other kind of case, but for an exposure case, I don't know how you prove some of the elements of it. I had one person make an argument that he was going to try to bring it under an occupational disease under 440.151. And, you know, of course, the problem with the occupational disease, it needs to be something that's not necessarily unique to his employment, but significantly more in his employment than anywhere else. And that's where he was going because his client was a nurse. And so that working in the ICU. And so that may give him a shot at an occupational disease case, and I don't know where it's gone since now they impassed it. So that will see what happens there. But I wanted to point out one thing: the federal government has its own workers' compensation law, of course, and they recently changed it. And what they did was they distinguished between 2 kinds of employees: high risk. If you get it, if you're a police officer or you're a nurse, EMT, if you get it, it's compensable. If you're not high risk, then you need to show some evidence that you got it at your job as opposed to somewhere else. Now, this is not the same. This is a much lower burden than ours, but it basically is just someone who may have worked at a convenience store or something who was more exposed to people coming in and out. So in the federal government, a lot easier to prove. If you're high risk, you basically win. So I don't expect we'll see that in Florida, but that's something to argue if you ever get there.
Okay. Jessica, have you had any of these yet?
I've had quite a few, and I think it's interesting what John Brooks just mentioned, because in my experience, the COVID cases I've had where there is a physician involved, a nurse, a CNA, those types of things, police officers, these cases are being accepted as compensable, and the claimants are getting benefits under the workers' comp statute for those types of claims. But otherwise, I'm seeing that the other injured workers, those cases are being denied. So that may be something that is parallel with that federal law.
Okay, great. I think we're actually out of time now, but I would like to thank all the attendees for appearing today, certainly coming to this. I hope we provided you some good information to help you have a more successful mediation. And I'd like to thank our panelists, Jason, John, and Jessica, for appearing here today and presenting a very nice presentation. But thank you all, and we'll see you at some other point.